You know, it's kind of interesting when you look at Brazil. They've got these laws, right,
Uh,
specifically meant to help young people get professional training, get into the workforce.
hmm.
But then actually getting access to those opportunities, it's not always straightforward. It feels like a bit of a disconnect sometimes.
Yeah, it really can be.
Yeah.
And that complexity, that's exactly what we're going to dig into today in this deep dive. We're focusing on Aprendizagem professional learning in Brazil.
Okay.
We'll be looking at, what it's for, the legal stuff behind it, based on all those documents you sent over.
Right. And you gave us a lot to work with. It looks like a really detailed guide mentioning the Constitution, the consolidation of labor laws, the CLT specific decrees, too, from 2018 and 2023,
Yep, those are key.
and stuff from the UN on disabilities, Brazil's own inclusion law, ILO conventions, court cases, even thoughts from legal experts and the public prosecutor's office. It's quite a stack.
It is. So our goal really is to help you, our listener, cut through all that complexity. We want you to walk away with a good handle on the main ideas, what's new, especially around inclusion and, making sure everyone's following the rules.
Okay, let's dive in then. What exactly is this Aprendizagem professional? What's the fundamental idea behind it?
So at its core, it's a public policy. It's got two main goals, really. First, fighting child labor, which is still a concern.
Right.
And second, making sure adolescents actually have the right to get qualifications, professional training. You see this backed up in the Constitution, Articles 214 and 227. The aim is to help them get a real foothold in the formal job market.
So it's more than just like any odd job. It's about a proper start.
Exactly. A qualitative insertion, as they say. And it's also about reducing social vulnerability, more skills, potentially better income of the family, that kind of thing. Legally, it's defined as a special type of job contract. That's Article 428 of the CLT. What's interesting is the setup. It's like a triangle.
Mm.
You've got the apprentice, the employer, and then this professional training organization.
A three-way partnership. And you mentioned the training organization has some independence.
Yeah, the law stresses that. They're autonomous. They're not just answering to the employer. They even have a role in checking up on the workplace, making sure it's actually a good place to learn.
Makes sense.
Now, something really crucial here is the quota, the mandatory legal reserve for professional learning.
Ah, the quota. Yes, I saw that mentioned. What are the key things to know there?
Okay, so basically every place that employs people in Brazil has to set aside a certain percentage of its jobs for apprentices. It's between 5% and 15%.
5 to 15%.
Right. And it's specifically for positions that require professional training. The CBO, that's the Brazilian Classification of Occupations, defines which jobs those are. It's all laid out in Article 52 of that 2018 decree, which got updated just last year by Decree 11.479.
So it's not optional. Companies have to do this.
Correct. It applies across the board to all employing establishments, even ones that are considered employers sort of indirectly, under Articles 2 and 3 of the CLT. And the key thing is, this isn't something you can bargain away. It's considered trans-individual, a right for society, so you can't negotiate it down in contracts or agreements.
Got it. It protects the opportunity for young people generally. So how do they figure out the exact number of apprentices a company needs?
Well, they look at all the jobs in the company that the CBO says require professional training. And here's an interesting point. It doesn't matter if some of those jobs are legally off limits for kids under 18. Hazardous work, things like that, banned by Article 7 of the Constitution.
Wait, really? So even if an under 18 can't actually do the job, it still counts towards the company's quota?
Exactly. The job type counts for the calculation, even if the apprentice hired for the quota can't fill that specific dangerous role if they're under 18. The CBO provides that sort of objective basis for the calculation. But it's worth noting, apprentices who are over 18 up to 24, they can do jobs that might be unhealthy, dangerous, or involve night shifts. There's more flexibility there.
Okay, so the quota is mandatory, but what if a company's work is just genuinely difficult for apprentices? Maybe it's really specialized or dangerous. Are they just stuck?
No, not entirely stuck. The law does recognize that practical issues can come up. So while direct hiring is the goal, there's an alternative path. It's sometimes called the social quota, laid out in Article 66 of that decree, 9.57.92018, as amended.
The social quota, how does that work?
Basically, even if a company argues its main business activities make hiring apprentices directly really hard, they still have to fulfill that legal quota. The social quota lets the actual hands-on training part happen somewhere else.
Ah, okay. So the company meets its obligation, but the apprentice learns the practical skills at a different place. Where can that training happen?
The decree lists a few options: public agencies, civil society organizations like NGOs, and also units within the national socioeducational care system. So it provides flexibility while still ensuring the opportunities exist.
Right, that seems like a practical solution. But you flagged some issues earlier with a specific SENEC program. What was going wrong there, according to your analysis?
Yeah, looking at that particular SENAC program announcement, three things jumped out as potentially conflicting with the current laws.
Okay.
First, excluding people with disabilities over 24. Second, requiring current school enrollment even for people who'd already finished high school. And third, making people take a paid SENAC course before they could even apply for the apprenticeship.
Okay, let's break those down. The age limit for people with disabilities, what's the problem there?
Well, it seems to directly clash with the law. Article 428, paragraph 5 of the CLT, it explicitly says the usual age limit, typically up to 24, doesn't apply to apprentices with disabilities.
So the law makes an exception specifically for them.
Exactly. And it makes sense, right?
Yeah.
People with disabilities are often a marginalized group, and the whole point of the legal framework is to encourage hiring them as apprentices, no matter their age.
That seems pretty clear-cut. You mentioned the UN Convention, too.
Absolutely. The UN Convention on the Rights of Persons with Disabilities, which Brazil has adopted with constitutional status, mind you, really stresses the right to work on an equal basis. It says states need to ensure access to training, placement, all that stuff. And Brazil's own inclusion law aims for the same thing, access and keeping people with disabilities in the workplace. So putting an age cap like that seems totally counter to the spirit and the letter of these laws.
Okay, what about the school enrollment requirement? Why was that an issue?
The Law CLT Article 428 and Decree 9.579 says you need to be enrolled in school if you haven't finished high school yet.
Right, that makes sense for younger apprentices.
But the SENAC program was apparently asking for enrollment in basic or high school as a prerequisite for everyone. That automatically knocks out anyone who's already graduated high school but is still looking for an apprenticeship opportunity, maybe someone between 18 and 24.
So it penalizes people for having already finished school.
It looks that way. Yes, the decree does say priority should generally go to the 14-18 age group, but there are definitely jobs suitable for apprenticeships like security or driving that legally require someone over 18 anyway. You know, these kinds of affirmative action programs, they shouldn't end up excluding other vulnerable groups, like young adults who finish school but still need that professional entry point.
And the third point, requiring a prior paid SENAC course. What's the argument against that?
Well, that really seems to undercut the whole inclusion goal, doesn't it? It immediately puts up a financial wall. Think about the very people apprenticeships are meant to help. Kids from low-income families, those coming out of the socio-educational or even prison systems, families on benefits, kids who used to be child laborers, unemployed youth.
Right, the ones who likely can't afford a prerequisite course.
Precisely. The decree, especially after the 2023 amendment, specifically says selection should prioritize including young people facing vulnerability or social risk. Requiring a paid course does the opposite. It filters them out. Some even argue it's like selling access to a job opportunity, which goes against principles like the Philadelphia Declaration about not commercializing labor. And it's maybe analogous to rules against private job agencies charging fees, like in ILO Convention 181. Even if Brazil hasn't ratified that specific one, the principle is relevant under the CLT. It feels like SENAC, in that instance, was acting a bit like a gatekeeper charging an entry fee.
So, given these pretty significant concerns, what's the right way to address it? The materials mention a recommendation from the public prosecutor's office. What is that exactly?
Right, the recommendation, a recommendation. In this case, it seemed like the best tool, mainly because it's fast.
Faster than other options.
Yeah, faster than negotiating something like a termo de ajuste de conduta, or TAC. The public prosecutor's office apparently had notified about this SENAC issue on April 2nd, and the event was scheduled for the 4th. Very tight timeline. No time for back-and-forth negotiations.
Okay, speed was critical. What gives the public prosecutor's office the authority to just issue a recommendation like this?
It's formally established. There's a resolution from the National Council of the Public Prosecutor's Office, CNMP Resolution 164 from 2017. It's also mentioned in their organic laws like LC 7593 and Law 8.62593. And the Labor Public Prosecutor's own internal rules also see it as a tool for fixing issues related to public services and collective rights.
Okay, so it's a legitimate, formal thing they can do. How would you define it? What does it actually do?
Article 1 of that CNMP resolution defines it pretty well. It's a formal notice from the public prosecutor's office. They lay out the facts and the legal reasons why something is problematic. The aim is to persuade the recipient, SANAC, in this example, to either do something or stop doing something, to improve services or respect people's rights. It's meant to prevent legal trouble down the line or fix bad practices.
So it's persuasive, not forceful. Is it legally binding? Do they have to follow it?
Well, it is a formal administrative act from a public authority, so it carries weight. But it's not coercive like a court order. It doesn't force compliance directly. Its power lies in its reasoning and the implicit suggestion that if the recommendation isn't followed, maybe more formal legal action could come next.
Gotcha. Are there specific principles they follow when issuing one?
Yes, the resolution lists quite a few. Things like, it has to be motivated, explain why. It has to be formal. It should be quick, celerity, public, efficient, legal, broad in scope, help access to justice, be useful. Importantly, it also mentions its non-binding nature, its preventive or corrective goal, aiming for a resolution, resolutivity, legal certainty, and proportionality. For the SENAC case, speed, effectiveness, and getting a resolution were obviously key.
And how does it usually happen? Do they just send it out?
Typically, it's issued as part of an ongoing investigation, like a civil inquiry. But in urgent cases like this one, they can issue it even before formally opening a full investigation, with the understanding that they'll start the formal process afterwards. And crucially, the recommendation should set a deadline for the recipient to fix the problem, and the prosecutor's office is supposed to follow up and check.
And it doesn't mean they won't take other action later.
Correct. It's not a replacement for a TAC that negotiated agreement or for filing a lawsuit, an ACP. They still need to monitor compliance. And there's actually a formal statement from one of their coordinating bodies, CCR Enunciado number 16, that basically says just sending a recommendation isn't enough to close a case. You need to check if it worked.
So putting it all together for the SENAC situation, what should the public prosecutor have recommended specifically?
Based on the issues, the recommendation should have urged SENAC to, first, postpone the event. Second, extend the sign-up period. Third, and critically, rewrite the announcement to explicitly welcome people with disabilities of any age and also young people who've already finished high school. And finally, remove that requirement about taking a prior paid course.
Okay, that covers the legal mechanics. What about how legal scholars see these things? Do they view Aprendizagem and these recommendations in a particular way?
Yeah, the readings you shared have some good insights there. Mauricio Godinho Delgado, for instance, he describes the apprenticeship contract as this special fixed-term deal that uniquely blends education and professional goals with regular employment stuff. He really emphasizes it as a way to bring more vulnerable people into the working world.
So a tool for inclusion.
Exactly. And Osorio Barbosa talks about the Recomendación as this written tool the prosecutor's office uses to sort of guide or instruct organizations, public or private, to pay attention to public interest matters or rights they're supposed to protect, setting a deadline for them to get it right.
Guiding them in the right direction.
Right. And Alexandra Emerald Gavransky calls the recommendation a really useful extrajudicial tool, meaning outside of court, for the prosecutor's office to protect rights. It can prevent harm, make sure rights are actually happening, or correct actions that threaten those rights. He links the power to issue these directly to the prosecutor's office's core mission, protecting public services and constitutional rights. There was that court decision, AGRG No Resp 762-440-RS, that supports this view too. Gavransky also adds that it's especially helpful in complex cases, or maybe when the entity involved is actually willing to fix things but could use some guidance from the prosecutor's office.
That provides some good context on the thinking behind it. Now, what about the court decision summarized? What were the main takeaways from the actual case law?
Those summaries really hammer home a few key points. First, the courts consistently uphold the apprenticeship quota as mandatory. It's not optional. They tie it directly back to Article 429 of the CLT and the constitutional right to professionalization in Article 227.
No wiggle room there.
Pretty much. They also strongly reinforce the ban on child labor and the need to protect young workers, referencing the Constitution and the Child and Adolescent Statute, the ECA.
Okay.
Another big one. Collective bargaining agreements can't just waive or reduce the apprenticeship quota. The courts are clear this is public policy and indispensable right, meaning non-negotiable. They even reference a major Supreme Court ruling on this, PEMA 1.046 and Article 611B of the CLT.
So unions and companies can't just agree to ignore it.
Nope. And some rulings specifically said jobs like garbage collectors, street sweepers, they have to be included in the calculation base for the quota. It's not just white-collar jobs. And failure to comply can actually lead to lawsuits for collective moral damages. One case showed that.
Wow, so there can be significant financial penalties. What about nonprofits? Is it different for them?
That came up in one case, RR 10246 39.2014.5.15.00061. It clarified things a bit.
Okay.
Nonprofits do have an obligation to hire people with disabilities under a different law, Article 93 of Law 8.2131991. But the court said that quota is separate from the apprenticeship quota for people with disabilities.
Separate quotas.
Right. Especially for nonprofits whose main purpose is helping adolescents and providing professional education, the ones mostly hiring apprentices anyway. The court reasoned that they shouldn't be treated exactly like a regular for-profit company for the general disability quota. The focus for them should be strongly on hiring apprentices with disabilities within the apprenticeship framework itself.
That makes sense. It's a nuanced distinction. And finally, that CCR Enunciado number 16 you mentioned briefly.
Yeah, that's straightforward. It just says that sending out a recommendation isn't the end of the story for the public prosecutor's office. They can't just issue it and close the file. They need to follow up, check if the recommendations were actually followed, and see if the problem got solved. Verification is key.
Okay. So let's try and tie this all together for everyone listening. This Aprendizagem professional in Brazil, it's clearly a really important strategy, legally backed, to tackle child labor and give young people a structured way into the workforce.
Definitely.
Employers have this mandatory quota. They have to hire apprentices, though there's a bit of flexibility with that social quota thing if direct hiring is genuinely tough.
Right, some flexibility, but not an escape hatch.
And a huge theme running through all this is inclusion. The law really pushes for these programs to be open, especially to people with disabilities, with that age limit waiver and other vulnerable youth.
Absolutely central.
And we saw how attempts to put up barriers, like in that Senate example with the age limits or paid courses, directly clash with the law's intent, and how tools like the public prosecutor's Recomendação can be used to try and correct that.
Exactly. So hopefully this deep dive gives you a pretty clear picture of the principles, the legal backing, and the ongoing efforts to make sure these professional learning opportunities in Brazil are genuinely accessible and fair for everyone who needs them.
Yeah, it really does. Hearing about this detailed legal framework, the strong emphasis on inclusion, it really makes you wonder, doesn't it? How well are these policies actually working on the ground across the whole country? Are they translating into real, meaningful chances for young Brazilians?
That's the million-dollar question, isn't it?
And what part can everyone involved, businesses, schools, the government play to make sure that the promise of Aprendizagem professional actually becomes a reality for everyone who should benefit? Definitely something to think about.